about the First Amendment protections that have been raised. Would you like to finish your thoughts on that?
Yeah, thank you for that opportunity. I really want to emphasize a couple of things. First of all, all the cases that are being relied upon by the state AGs and these private organizations involve the use of a subpoena to obtain membership lists or name of members of organizations. That was the case in the Wilkinson case, the Barron Black case, numerous other Supreme Court cases involving the House Un-American Activities Committee. It also was the case in NAACP versus Alabama. It was the case in the Gibson versus Florida Investigative Legislative Committee, which was cited. And that's a fundamentally different question, because what the court says in the membership list cases is that when you turn over a list of the names of people who belong to certain organizations, that clearly implicates First Amendment associational rights, because it can chill those associations. It should be noted for the record that this committee's subpoenas are not seeking membership lists. It is seeking ordinary documents and communications shared amongst these groups and with the attorneys general. That kind of information is routinely turned over in civil litigation. There's a Federal Rule of Civil Procedure 34, request for production of documents, that makes these kinds of documents routinely available. When it's issued against non-parties, Federal Rule 45 allows a subpoena ducis tecum to obtain these kinds of documents and communications, and they have never been thought to implicate any First Amendment rights. If turning over simple communications amongst parties implicated First Amendment rights, Federal Rule 34 and 45 would be unconstitutional, and that's simply not the case. Also, let me just point out, in those membership list cases, those only succeed when the organization whose membership is sought to be turned over can make a prima facie evidentiary showing that turning over the names of the members will result in intimidation or harassment of the members. That certainly is not in play here. And even when it is potentially, the courts don't buy those arguments. Just in 2015, the most liberal federal court of appeals, the U.S. Court of Appeals for the Ninth Circuit, held in a case involving the Center for Competitive Politics that organization had to turn over its membership lists despite its First Amendment objections.
Amplifying on that, in your view, does Backpage Court differentiate between the First Amendment protections in the realm of a congressional investigation when such investigation may implicate a criminal activity as opposed to an investigation where the subject matter is decidedly not criminal in nature?
Is that directed to me, sir?
Uh-huh.
Yeah, yes, that's a good point. In fact, I really want to emphasize that the cases that have involved First Amendment objections have all been in the context of criminal proceedings. It hasn't arisen in the civil proceedings. In those limited proceedings, the only objection has been executive privilege. And it's never, the First Amendment has never come into play in any of the inherent contempt authority cases of the Supreme Court. When it is a criminal case, it is a different show, right? Because there are heightened considerations about special constitutional rights that attach to a criminal defendant. So courts are particularly sensitive in criminal cases in a way that they're not in the civil or the inherent authority context.
Professor Rotunda, in your opinion, what is the best method for carrying out scientific inquiry on an important question such as climate change?
Doing it without fear of prosecution, without fear of threats of prosecution, without having to turn over tons of documents